Morning session is going to focus on Part 16 violations from a legal perspective, and we're looking to assist airport tenants in identifying potential federal grant assurance issues stemming from unfair treatment of the tenant by the airport sponsor, or using the Freedom of Information laws to obtain evidence in support of a proposed Part 16 action, or using a proposed 16 complaint to get the attention of the airport sponsor with respect to issues of unfair treatment of the airport tenant. And lastly, using the threat of a Part 16 complaint to effectively negotiate the resolution of the issues identified therein. I'll warn you, I am a step-in moderator, so I'm not completely familiar with this topic. I fully expect to learn something myself here, but we have two distinguished guests. Our first speaker is David Cushing. He currently serves as the FAA's manager of the Los Angeles Airport's district office. From 1996 through 2011, Cushing worked in the Airport Compliance Division in FAA's Office of Airports. In that capacity, Cushing drafted some 50 Part 16 decision documents. And with that, I will let David get to his presentation.
Well, thanks for the introduction, and thanks guys for coming. And I see we're kind of early this morning, so people are trickling in. Do we have, in this crowd, do we have FBO? Do we have airport sponsors? Do we have users? What do we have? FBOs over here? Sponsor? Some FBOs? Okay. I am David Cushing. I do come from compliance. I just started this job in Los Angeles as the airport's district office manager, which is the field office for the FAA with airports, largely to do with grants and planning and programming, environmental analysis for airport projects, and just general relationships with our field offices in Southern California and Arizona. But before that, I spent 15 years doing compliance, which is the Part 16 topic that we're here for today. And the Part 16 process is the way the federal government, investigates complaints of non-compliance by airport sponsors with their federal obligations, which are mostly grant assurances. So, okay, yep, this is the wrong one. Okay.
Yeah, there you go.
There we go. So, I mean, with all these years, and it is true, I think I've probably written more of the decision documents than anybody else. So why I left that to come to California, I don't know. But one of the things I like to make sure audiences understand, and this presentation has largely gone to sponsors, to explain to sponsors what our relationship is with them, because the agreement is with the airport, but how we look at the compliance program. And generally speaking, we have simple grant assurances. There are 41 grant assurances, and we use these to protect the public's interest in civil aviation. We want to ensure that surplus property, deeds of conveyance, and airport improvement program investments serve their intended purpose, generally to be available for use by the public, including aeronautical businesses, to make air commerce happen. That's why we have the airport improvement program. That's why we have surplus property. Now, in this, we're not regulatory. These grant assurances are an agreement, so they have to recognize the proprietary rights of the sponsor. They own the airport. We want them to be engaged as a prudent business manager of their important asset. They just agree with the federal government that if they're taking this benefit, they're going to do this, exercise their proprietary rights in a way which serves the public's interest in civil aviation. So there's basic rules about how to make that happen. And also, to our program, we need to be convincing. We need to make sure the public understands what we're doing so that they kind of buy into it. And that means the whole public, even just the ticket taxpayer or a random uninterested party that is a citizen of the United States of America. They want to know that their taxpayers' dollars are being spent in a reasonable way and that we have legitimacy and we know what we're doing. And I can tell you that the group of people that I worked with and still work with, they really do care about these principles. And so we look at it that way. We are defending the public's interest in civil aviation. The program is not a lawsuit kind of situation. It's not about damages, which I'll talk to you a little bit more later. Our grant assurances are our principles. It's like, I don't know, 11, 12 pages of of grant assurances, it's not that horrible. You know, it's pretty simple. And surplus property deeds of conveyance are the same. You know, when you get property from the federal government, we expect you to generally behave in a responsible way and to protect the asset for aviation. Sponsors agree to these rules voluntarily. You know, nobody's got a gun to your head, so to speak, and that you are dealing with the federal government when you sign on the bottom line if you're a sponsor, so you really should understand how you are obligated to deal with the public and deal with aeronautical businesses on your airport. Now, grant assurances, like I say, and deed covenants are commonly at issue. We'll talk about them very briefly, but there are some things that are federal law, and that is to say any sponsor, any airport owner that has engaged with the federal government or has been the recipient of federal government assistance must always preserve its revenue. There are some questions about that, but about the timing. But generally speaking, almost any sponsor you deal with today will be required by law to adhere to airport revenue retention. They have to keep the airport revenue on the airport and not allow the mayor or the city council to take it downtown for non-airport purposes. So exclusive rights is also a federal law. Exclusive rights is they can't just hand over the airport to one individual private party. They can operate a proprietary exclusive, but they can't grant the exclusive right to the airport. And that's law going back to the 30s. It's like antitrust law. And then civil rights goes forever as well. Here's some of the grant assurances. We'll talk about them very briefly. Grant assurance 19 is that thou shalt operate and maintain your airport in a safe and serviceable fashion. Paul has a slide where he talks about a recent case in Glendale, Arizona, where we reached into what a tenant was doing inside the hangars, using them for non-aeronautical storage. We'll talk a little bit about that, I think, in his slide, and there's a line about where that grant assurance goes. Generally speaking, you have to operate and maintain your airfield, the sponsor, airfield in a safe and serviceable condition, considering climatic conditions and also a repair schedule. Sometimes you have to rehab it, so that's an understandable thing to do. So generally, we think about it as the airfield. If operating the airport is being done in such a way that it destroys the value of the airport, like creating blight or undermining the value of aeronautical facilities around it, that's when Grant Assurance 19 might reach out from the hangar and become a violation, a poor maintenance or operations of the hangars. Grant Assurance 29 is the ALP Grant Assurance. It says thou shalt have reasonable plans and thou shalt not deviate from those plans. And if you do, we may make you change those changes and correct them. Grant Assurance 22 is the main thing we'll talk about later. It's just that you have to treat your users reasonably on reasonable terms, including reasonable charges, and without unjust discrimination. We'll talk more about that later. Grant Assurance 23 is the exclusive rights grant assurance about not granting a monopoly, and 24 is similar to 25 revenue retention. You got to have a schedule that keeps the airport self-sustaining. So you've got 22 saying you can't charge unreasonably high fees, and 24 says you have to charge fees that are reasonable enough. So we're kind of creating a box here for airport sponsors to say, you know, give us a fee schedule that's reasonable, not a usurious, but also has a way of keeping your airport going and paying for your operations. Now, we have a standard for compliance. When we get a complaint and we're examining the evidence, or we just come across a compliance issue, it's important to understand what our benchmark is. And it's not quite as regulatory as other, well, it's not regulatory. It's not like flight standards regulations that some of you are subject to. It's an agreement. It's a contract. So we want to make sure that the sponsors understand their obligations and that they have a program. They're implementing those, and that the program is reasonably aimed at success. It's not a crazy or unlikely to succeed program. And that past compliance issues have been addressed, that they're either resolved or on their way to resolution. Sometimes it's hard to unravel past non-compliance, so it takes some time. So if an airport's on a path of correcting, because a lot of times I tell you, with these complaints, we get a complaint because the airport sponsor is correcting past non-compliance. That the entities on the airport were used to the old regime and don't want to change to the new regime, but this is pretty common, quite frankly, that the steps to take to get to a better state or a better business practice is causing discomfort with their lease agreements or discomfort with their contracts. And we have said repeatedly that that is not going to be non-compliance. Doesn't mean that it never is, but that it at least is good evidence that it's a compliance situation. We have said this in cases. This is a quote from one of our recent cases. We don't take these actions lightly because to cut an airport off, which is our only real resource, undermines the utility of the airport. We're shooting the capital improvements in the head as punishment for a bad act. So we don't have the ability to put anybody in jail or take away their airport manager's license, which doesn't exist. So our solution is to no longer invest taxpayers' money into the airport because we're protecting the taxpayer and the public's interest in civil aviation, and the first step is to not spend money. So generally speaking, we look at these as opportunities to educate the airport and change their practices. So once they change their practice to one of not violating the grant assurances, then we're done. Whatever damages may have happened or occurred, that's between the parties, not with the FAA. So if the airport changes its practices from a non-compliant status to a compliant status, it's over. We really believe, and Paul can add to this too, that in informal complaints to flesh out issues and keep them from becoming more problematic, because once it gets to the formal stage, a complainant rarely gets satisfaction. They rarely achieve their business aim. One of my most recent cases, in fact, they very much did. So, of course, there's examples in which when questions are simpler, like give me access to a drop zone, no, you can't have access to the drop zone, or there's no insurance for skydiving. Get insurance. Oh, there's no insurance? Okay, you don't need insurance. If it's a simple question, it's very rare that they're simple. That can sometimes redound to the benefit of the complainant. But once it gets to a formal, it's usually just misery for everybody. So we like that because the FAA, and in my new role, I can offer assistance at informal. I can actually kind of sit down with the parties and say, well, try this, or why don't you do it this way? Whereas in a formal complaint, you can't do that. It's just, yes, you're right. No, you're wrong. Here's our judgment. So, we really believe that here's some of the requirements and some of the characteristics of a Part 16. The major point of this slide is that the question that we have is the sponsor in compliance or not in compliance, not whether has the sponsor been fair or unfair, or whether someone's been hurt, or whether a business plan is ideal. A lot of times the question before us is, it would be perfectly reasonable for the airport to do what we want them to do. Please examine that question. The complainant might say, they could agree to my deal, but that's not the question that we ask. We ask whether the airport's position is unreasonable. When you're in a situation of negotiation and it's fluid and they're going back and forth, oftentimes we get a complaint that says, at this point in time, the airport's position was unreasonable. But by the time the complaint gets vetted, the position's changed like 3 or 4 times, and it's like, yeah, you're right, okay, that momentarily the airport was in non-compliance, but it's not anymore. So those can be very difficult, and we write that. We say Part 16 complaints that are subject to ongoing negotiations are very hard to deal with, and they very rarely resolve the issue. And the main thing is that there's no damages. It's not a lawsuit. There's no ability to make any party whole from a Part 16. So this is some of the timelines. It can take a while, and I have to tell you, since I left compliance, I left kind of a hole. But anyway, there's some low staff situations in compliance. But I can tell you too that just last week we issued our notice of proposed rulemaking to amend Part 16 in some technical lawyerly ways, which I meant to tell you earlier, which we hope can make it go faster, expedite the process, and explain it more. I can't really comment on it except to tell you that the docket is out there, and we would invite comments for our proposed changes to Part 16. So to conclude, I do tell the parties to take it seriously, understand the process, respond to each allegation with evidence, tell us a story with facts, recognize obligations and responsibilities of both parties, send pertinent supporting documentation, don't flood us with non-relevant information, and this is our fun list of things not to do. Don't call names. I would say don't spend a lot of time imputing motive or bad motive on the airport. If you know the airport is motivated for poor reasons or bad reasons, I've actually written the words. Motive alone is not a grant assurance violation. You actually have to show what they're doing, that they're in a state of non-compliance. So, it could be a paragraph. Yeah, you could mention it, but a lot of times complainants have gotten themselves in trouble by over-explaining why the airport's motivated not to like them, because then they end up explaining why they're kind of unlikable. And that's happened repeatedly. Well, maybe the airport has a point to not really want to do business with you. So, here's my favorite thing. Do not send me a copy of the grant assurances. Do not do that. I just have to index it and carry it around. I know the grant assurances. We do. So don't send unnecessary, don't bring up unrelated issues. And I think for sponsors, we'd like to tell, don't be afraid to admit that you did something wrong and correcting it, because that's always a good place to go. You can change your business practices for the better. And this is what I'm talking about. We are considering rulemaking. We're not considering rulemaking anymore. We are in a rulemaking phase. So we are accepting comments on proposed rule changes. So with that, I'll hand it over to Paul, and later we'll take some questions. Thank you.
Thank you, David. That was wonderful. Next up, we have Paul Lang. The offices of Paul Lang works with clients nationwide who are either pursuing or defending against the threat of a Part 16 complaint and any related litigation. Mr. Lang has began handling airport matters as an FBAA attorney and brought that perspective to the private sector after leaving federal service. He and his firm have successfully resolved numerous airport regulatory problems and disputes over the years, including negotiating favorable resolutions both prior to and after the initiation of Part 16 actions and litigation in federal and state courts. Paul, why don't we come up here and have you tell us what you know.
Had it first time. There we go.
All right. Oops.
Thanks, Brad. The good news here is I've got 38 slides for you. The better news is that I'm going to blow through a bunch of them because we don't have enough time. The way we decided to structure this was about 20 minutes, 20 minutes, and 20 minutes. So we want to leave about 20 minutes for questions at the end. The other thing that I wanted to tell you at the outset, why we decided that Dave should go first is to basically lay out the FAA's position. When we were preparing for this, Dave and I were talking a little bit, and we decided that there's an awful lot that Dave never sees. Dave asked me for a number of the airports and matters that I've been involved with. He wanted to check conflicts. And there was a fair number of them he'd never heard of because they never actually made it to a Part 16 complaint. He never saw them because they were resolved in advance through a variety of means and ways. So Dave has already laid out the law essentially for you. If anyone wants to leave me their card afterwards, I'll email you the presentation. That way you have all the citations and all the details. But I'm probably going to rush through about the first 22 slides because that's going to get me to the point where Dave hasn't talked to you, the parts where Dave doesn't typically see the problems, where Dave was discouraging you from a formal Part 16 action and a complaint. I'm going to tell you all about the setup and how you get there and how you organize it, which an awful lot of times doesn't even make it to the Part 13 informal stage and gets things resolved. You don't always get everything you want, but hopefully you get there actually quicker and with a little less risk. I think Dave went through pretty well what is a Part 16 complaint. I'm not going to go through a whole lot of detail here. You've got citations. You can look at the various ways that they can arise. Who's eligible? You typically see them in with respect to FBOs, but it can be virtually any airport tenant or anyone who wants to use the airport and is aggrieved in some way. Who do you file a Part 16 against? Well, it's airport sponsors who are actually bound by the grant assurances. There's time limitations on those and so on, how long they last, and there's differing time frames that you'll have to research. Some of them. I think Dave went through what exactly are some of the federal grant assurances. I've got some of the most common ones outlined later. We talk about some exceptions here, and those we can deal with in specific cases as necessary. What about spotting a potential Part 16 issue? They come up in a variety of ways, but you tend to see in places where underutilization of airport property. We've talked about non-aeronautical uses at an airport. There was one case about a cabinet-making shop at an airport. We often see a lot of little disputes where you have T-hangar owners where they put a boat or boats in their T-hangars, and that seems to happen more often than not. The smaller the boats, and as long as you have an airplane in there, it tends not to be as controversial as when it turns into a cabinet-making shop, which is fairly obvious and large. Capacity limited airports, we were talking about one in Key West. There's just no more land there to expand onto, and when somebody else wants to come in and compete and there's no more land, what do? You can naturally see some of the disputes. And in this day and age of economic difficulties, airport sponsors are looking everywhere for new sources of revenue. These are where the tensions tend to be, where you see many of the tensions, where we see a lot of our cases coming from. We pulled probably the 4 most common grant assurance violations that we see coming across our desk, and looking at the decisions that Dave used to write. And they're grant assurance 19, operation and maintenance 22, economic discrimination that Dave talked about, exclusive rights 23, and then also the airport layout plan, dealing with leases and whether or not they're actually added to the airport layout plan. I'm probably going to go, Dave talked a little bit about some of these, and I'm going to go through them quickly. The operation and maintenance, you can find more detail if you go to the FAA's Airport Compliance Manual, their Order 5190.6b. Many of you are already familiar with that, I'm sure. Here's some of the things that the FAA is going to be looking at with respect to a Grant Assurance 19 issue. Dave has talked about those sorts of things, wanting to make sure that the airport sponsor understands that airport facilities must be kept in a safe and serviceable condition, makes available equipment, personnel, funds, and so on in an effective maintenance program, and adopts and implements a detailed program of cyclical preventive maintenance adequate to carry out the commitment. Now, what are some, Dave actually mentioned this Valley Aviation versus Glendale case, came out in May, but allowed non-aeronautical use of airport hangars for storing non-aviation items for operating non-aviation related industries such as a cabinet making shop. A lot of these things are very, very fact specific. That's why Dave, was want to write lots of opinions that were easily 60 pages in length.
I didn't write those.
Dave says he didn't write the 60-page ones.
I was the 40-page wonder.
But some of them are just, because they are so fact specific, the responsible person in Dave's position when he was in Washington writing these things is you actually have to go through all the evidence because the facts are so important, because you can't take that issue and how it's decided in one case, in one part of the country. The facts might be just slightly different enough at another airport in another part of the country so that it's going to end up with a different result. That's how you end up with the 40-page decisions in Dave's case and 60-page decisions when other people are writing them. Non-discrimination, we get these all the time. And basically, the airport needs to be made available to the public. The airport has taken public funds, and you've got to keep it open and available to the public. Dave actually gave you some examples here, and I want to keep this moving about where there's some issues. I'll give you one quick example that I had with a parachute drop zone that was some time ago that was actually entertaining, and the airport manager, if you can imagine this, on one side was a military veteran who ran a bunch of military airports, very spit and polish guy. On the other side of the coin, the parachute drop zone operator, who had lots of young people camping on the airport, allegedly smoking marijuana in the evenings, and in the end, they set up a shower on the airport, and they had a number of young women running around in the warm evenings, perhaps with their towels falling off. Airport manager didn't like this very much and actually chased some of these people down in the evening because he thought this was so terrible. Well, some of the young women actually report airport manager to the state police, calling him a peeping Tom. And he ends up on an appearance ticket in a criminal court as a peeping Tom. All of this because the airport manager wanted to build up his airport into more of a corporate airport serving jets rather than having the parachute drop zone there. And so that one never actually made it to the FAA level. Yes. More often than not, you hear about the phrase, all politics are local. Some of these things you just can't make up. They're not very entertaining to the parties involved, but guys like Dave and I that look at these things, you shake your head and you say, you couldn't make this stuff up. We've got some other cases here on some recent cases, 2010 and 2011, on economic non-discrimination, where it was found to violate and not violate Grant Assurance 22. I'll leave you to take a look at those later. And you can get all these cases at the FAA's website. They've done a better job of actually being able to find it using the search function, but you can't actually get, oh, that was yours?
Well, kind of.
Okay. Well, thanks for the better links to it, because when I'd lose a bookmark and I had to go find it again, it had been difficult a few years ago. So anyway, they're well worth reading when you have a problem. We'll skip this slide on exclusive rights, and we've talked about that a bit more. Here's some more cases where we talk about denial of access to electrical supply that violated Grant Assurance 23, but denying fueling rights to a SASO but allowing to an FBO did not violate, and that seems fairly straightforward there. Airport layout plans, I mentioned to you earlier, whether or not you add it to a lease, add a lease to the ALP. That's come up a few times in Part 16 cases. Take a look at the airport compliance manual for that. Here's some cases on the issue, both where it was found in violation and where it was not. Now, here's the part where we get into a client would come to us, and this is long before the FAA knows about it, even at the airport's district office. Sometimes they might have an inkling of it when the local airports inspector is taking a look around and trying to keep an eye on what's going on at the airports, but they're not always going to see the things that are behind the scenes that are brewing. A theme here over the next 10 or so slides is really that you need to be organized. You're going to save yourself time, money, effort, problems all along the way, not only in legal fees, but you're also going to have a better result with the FAA. You're going to have a more compelling case, and you're actually going to find the holes in your own case when you actually try and put it together. You set up a timeline. You say, here's what happened, and you have it annotated. You know, I suggest to clients that they actually have a loose leaf notebook, electronic or actually hard copy. And then you start laying out a timeline, and you have a table of contents, and you put tabs with your evidence. And you say, here's my evidence to support this position. And when you actually go through that exercise, I mean, when Dave and I were preparing, we talked about this, and more often than not, what he sees and what I see is people who don't do that. And they're essentially either spending money with me or taking up Dave's time to then have both of us tell someone with a complaint that there's a variety of problems in your logic. And you can save yourself a lot of that effort if you just start out being organized. And this may sound, just very simple and straightforward, and everyone sitting here would probably do it. But still, it seems like about 85 or 90% of the matters that come both our ways just don't have that in advance. Now, the other thing you can do is, we talk here about the various types of evidence. Everybody walks around with a cell phone camera now, but it's still surprising when people complain about, my competitor is doing A, B, or C. It's, well, why don't you give me a picture? Do you have a camera on your cell phone? Yes. Can you take a picture of it for me? Can you show me that the corporate self-fueler is actually fueling itinerant aircraft? And say, gee, that was a pretty good idea. And then so we start pulling teeth and gathering this stuff. Gather your documents that are publicly available. Your competitors' advertisements that you think are offensive and in violation of grant assurances. Airport commission agendas. Again, all politics is local, and it's amazing to me how many airport commissions think that they can do whatever it is that they want, and it's almost laughable at times. Gather and organize your documents, leases, letters to or from the airport manager, emails to or from the airport manager. Freedom of information requests. Assuming that you're dealing with a public agency sponsor, they're subject to requests for documents, correspondence, emails in accordance with state and federal Freedom of Information Act laws. A lot of people think that, okay, we're in the aviation business, you deal with the FAA all the time on a variety of things, you automatically issue a FOIA to the FAA, the Federal Freedom of Information Act. Many states, or actually most states, have their own version of the federal FOIA. Sometimes they call it FOIA, sometimes they call it FOIL, for Freedom of Information Law. But you're going to have an opportunity, typically under the state FOIA or FOIL laws, to actually get more information than you will from the FAA. Remember, the FAA has to have it in their possession in order to give it to you. And a lot of your complaint is probably going to be based upon what you get under your state and local FOIA law. The scope is just wider of everything that's going on. Consult your applicable state statutes for exemptions and that sort of information, but generally they're going to track. You want to submit that to the relevant authority as soon as possible, as early as possible in the process. You can ask for it informally. It really depends on how you want to approach the matter and what type of relationship you have with your airport sponsor. But you can ask for it informally. If you don't get it informally, or if you want to make a point, you can start with your state FOIA request. Responses are typically going to be piecemeal or incomplete. They're going to necessitate follow-up correspondence, but do all that stuff. Do it for yourself, and it's going to tell your airport sponsor that you have a problem with, that you're serious. This is long before you ever end up in a Part 16 case. Moreover, it's going to actually help you create your case. Don't you want to be prepared and actually know where the holes are in your case before you actually start litigating it? What types of documents can you typically obtain under FOIA and FOIL? And then this is, again, the exemptions are going to differ slightly, but you can get airport minimum standards documents, prior iterations of, revisions to, discussions and negotiation about them, lease, sublease, and amendment documents pertaining to other tenants at the airport. There's typically going to be exemptions about negotiation documents are, typically not going to be producible. You can make arguments in certain places after the lease is finalized to get some of that stuff. Really is a state-by-state issue. Requests for proposals, submissions and response, and associated documents, research and studies done by the airport sponsor prior to the issuance of an RFP, particularly if they're targeted at bringing a competing FBO onto the airport, correspondence between the sponsor and the FAA. I've got a bunch of other issues here that you can actually try and get, but I'm going to, in the interest of keeping things moving here, I'm going to keep going. What about expenses on your FOIA? That's going to vary by the statute you're operating under, state or federal. You want to take a look at that. One of the suggestions that a good practice that I learned actually very early on when I was at the FAA was that you might want to actually offer some money up front. You don't have an absolute right to these documents at no cost, but if you have a sense of what you're asking for and you're willing to pay some money, I would suggest that the government's going to charge you for search and retrieval time, and they're going to charge you for copying the documents. So if you go in and you ask for a variety of documents at and you think that it's going to cost you at least $300 or so, then you write your FOIA request and say, I authorize in advance up to $300 in charges, and if you anticipate it exceeding that amount, then please call me in advance, and then you have a discussion. So those are some of the things you want to look at to help expedite the process for you. In the interest of time, I'm going to move through this slide a little bit on the RFPs, but and we already talked about using if not the threat of a Part 16, but the suggestion that this is moving towards a Part 16 to get the attention of an airport sponsor who might otherwise not be paying enough attention to you. We talked about the FOIA or FOIL requests up front, collecting the evidence, but really just sitting down and having a discussion with your airport sponsor. Multiple discussions sometimes are very useful to get things going. If you need to, then you follow up in writing so that you can use it to support your good faith requirements, your good faith efforts under Parts 13 and 16 later on down the line. Remember that all your written communications are likely to become evidence at a later date. Just because you think that it's wonderful that you can get everything on your competitor under FOIA, they can get everything that you write to the airport as well. We talked about pre-complaint resolution and the requirement of good faith, and that you've got to show that you have good faith efforts. The efforts at informal resolution can include mediation, arbitration, use of a dispute resolution board, or some other form of third-party assistance. A lot of times you can just use the fact that you've got an email, you've got letters back and forth, you've got meetings that you confirmed in writing. All of those are useful to support your good faith requirements, which is a requirement for Part 16 if you get there. Okay, in summary here, so that we have some time for questions, know and follow Part 16 and the FAA's Airport Compliance Manual. Obtain information early under FOIA and FOIL laws, and most importantly, just organize your evidence, create a timeline of events. Yeah, I'm hearing the comment here. I'm not sure if it's the correct term. Dave, it seemed like he swooned when I said, here's what I tell my clients to have. Use a loose leaf notebook. And he said, oh, goodness, wouldn't that be wonderful if when I got the informal complaints, if that actually occurred. That's probably the best advice that I think both of us can give anybody in really leveraging a Part 16. There's a lot of work that leads up to it, and that leveraging actually helps you get to the point where probably more than 50% of the matters that I've handled, the FAA never even saw, because they were resolved even before you got to the informal stage at the FAA. So I'm already a couple of minutes over. We want to have time for questions, but thanks for coming first thing in the morning to listen.
So I hope you all got something out of that. I certainly did. Definitely an education. I have one question to feed my own curiosity to pose to the panelists, and then I'll turn it over to the audience. But I'm really curious if you identify any commonalities between Part 16 complaints in terms, I guess, from a cultural standpoint at the airport or the tenants. Identifying some underlying issues that lead to contention between airports and tenants, because I notice as an editor of Airport Business, most of the folks that I go interview are kind of success stories, and they really have a good working relationship with the airport. So please.
Well, I mean, I guess it goes without saying that the Part 16s, once you get to a Part 16, you have a dysfunctional relationship. So the folks when the parties know their own minds, they don't have to be on the same page, but we find that bad sponsors attract bad business people, and that then they get into this relationship. So bad decisions beget bad decisions, and so then they're both motivated to continue their bad behavior. It's not so much that an airport sponsor and an airport business might not have exactly congruent goals, but when each party knows what they're doing, and especially when the business operator has a business plan, and like most of the folks here, I mean, there's an airport business is a business. It must have a business plan, and the business plan shouldn't be to be a flight instructor and kind of make a go of it, and then when things don't go great, complain. I mean, sometimes that happens, and then from the sponsor side, not paying attention to their grant assurances, not returning phone calls to somebody who's not happy. I mean, I don't know how many complaints that the airport got into trouble because they wouldn't clearly say thank you but no. Okay, and so that sort of clarity of mind and a willingness to communicate that from both sides, I think, is the frustrating, almost kind of tragic-y feeling thing that can happen. You could think this could work if these folks would just communicate and clearly and know their own minds. And maybe I'm come from government, so I understand that the government officials that I deal with, oftentimes the airport manager is also the public works manager, and he's got a city manager and a mayor and a city council and the federal government. It's harder for governments to know their own minds because they've got so many people complaining, whereas a business is oftentimes can be very focused. The Key West case that you did not work on, that I worked on, the airport, Key West, was put into non-compliance because they just didn't want to deal with this guy. Because this guy says, I've got a helicopter, and I want to have a helicopter business. And every time he thought maybe he could get something, he'd change his business plan. Well, I might want to do sky signs, or I might want to do this. And he was always all over the place, not just with the airport sponsor, but with us. So no one knew really what his point was. The airport just didn't return his calls. It was margarita time in Key West. So they said, well, we'll get back to you in November. And it's like June. It's like, you can't do that. So we put the airport in non-compliance. We said, you don't have to give this guy a nondescript lease agreement that has absolutely, there's just this loosey-goosey, and Key West is a special situation because it's so constrained. You really, it's hard. It's the poster child for an airport that might have to have all of its leasehold kind of controlled by a single party, perhaps, maybe. But in this case, the guy didn't make a case that it was a problem. But that's a perfect example of parties not knowing their own mind. The sponsor didn't know, the complainant didn't know what he wanted to do, and the sponsor didn't understand its obligations to simply deal with the guy in a forthright manner. So that's my example. It's not working. Maybe I can.
And all I have to add there is that a lot of times in the matters that we see, you have an airport manager that doesn't know a whole lot about aviation. It might be the public works manager who did really well in that role, and then airport was a problem, and they put public works manager in charge of the airport. So an airport tenant might not see eye to eye with that person, and we see then disputes then start to develop because of a personality conflict. And where we've been able to resolve a lot of problems up front is then by actually pulling out sections of the grant assurances, pulling out some Part 16 opinions and highlighting parts of the 40-page decisions.
16-page one.
You had a 16 one? Oh, okay. 16-page Part 16. Okay. All right. Or portions of the airport compliance handbook. And when you actually say, look, here, I want to explain my position, and here's what the law is, here's what the CFR says, here's what the statutes say, here's how it's implemented, here's the case law that describes it, here's how the FAA is going to approach it, let's sit down and see what we can work out. And in actually a fair number of cases, the parties can then actually, get to a resolution before you ever get to the FAA part. Now that's where you have someone who is just not that familiar with aviation. I mean, do their homework for them. Simple as that. Hopefully that answered your question, Brad.
Very good, gentlemen. Obviously, communication is key in this process. I'd like to open up questions to the audience. If anybody has anything they'd like to ask Paul or David. We got Oscar out there, TAC Air. I can't get you to ask a question, can I? Sure. I have a mic right over here.
It was mentioned earlier, an example was given of a potential tenant wanting to come to an airport and start a business of some sort, and yet the airport was landlocked. How do you resolve something like that? What generally happens if that's the situation?
Well, that's a little bit. It depends. I mean, the law itself for exclusive rights actually states that the airport sponsor does not have an obligation to go chop up existing leaseholds. So this has always been the conundrum that the concern that an airport sponsor can back itself into doing that. When you have a very small airport, and that it's conceivable that the exclusive right or the no more room in the inn is okay. It's acceptable. That you can't make it happen. I can think of a few examples. Key West being one of them. That the idea that it was just not feasible to have more than one party chop up the ramp. This is an airport, and this is a case where an airport had to be the GA airport, the commercial airport, the only airport on the island. So it was very constrained. I mean, another airport that comes to mind. Well, actually, the Boston Air Charter case, I think, was really an interesting one because that is a situation where we agreed with the complainant that even though the airport may not have done anything deliberately going into it with the mind to grant an exclusive right, by failing to retrieve the rights to run utilities to spots of the airport, they've effectively granted an exclusive right. And we said, you have some tools to try to fix it. and they just didn't pick up those tools. Because we don't put the airport in non-compliance if they pick up a tool and it just doesn't work. The airport doesn't have to go be sued out of the wazoo for trying to break up a leasehold that a judge is just not going to let them do it. So that can happen. But what we work on is to make sure that an airport doesn't land bank from the beginning, doesn't over-grant leaseholds. And when an airport is starting and they want revenue, and it's the public works guy who says, I don't want to lose money on this thing, some airport business comes along and says, I'll lease up the whole thing and you'll have a check, and he says, you don't have to worry about it. But then the entity, that's where you create your future exclusive rights problem. Because the business doesn't really need all of that land. They clearly don't need all the land. So we get worried about that. So that can be a problem. But in some very rare cases, it can be that the leaseholds will have to survive and the business opportunity will have to be somewhere else. But that's pretty rare.
Well, thank you, David. In the interest of time, I'm going to close it up here. Please feel free to come up.